Good morning. Good morning to this challenging Saturday morning session. But I'm sure that we will live up to your expectations, and everyone who is coming in will miss the exciting starting part of this panel on finance and human rights. My name is Reinisch. I'm a professor of international law at the University of Vienna. I'm not an expert on finance and human rights, so I'm very much looking forward to this panel because I will learn a lot from an excellent group of panelists who I would like to very briefly introduce. My warm welcome goes to our first speaker who will join us online, Cynthia, Nona, Tamale. Good morning. Can you hear us? Excellent. Yeah, I think you can hear us. We still have to work on hearing you in this room. Cynthia is an assistant lecturer at the law school Makerere University. She's graduated from there and Harvard Law School and focuses on development finance, particularly sovereign debt, climate finance and human rights. She has published in the field. She has worked with international organizations and entities, among them the UN Department for Economic and Social Affairs, Oxfam, African Forum, and Network on Debt and Development. She also supports the Special Rapporteur on the Right to Development, and we are very much looking forward from hearing from her on sovereign debts, human rights considerations. Then here in the room next to me is Kanad Bagchi, who is at the Amsterdam Center for International Law. He's a postdoc fellow since September 2023, and his research interest is on public international law, political economy, and money. His research interest and background is described as embedded within the tradition of TWAIL. Those who are not public international lawyers, we love these acronyms, Third World Approaches to International Law. Marxist political economy, he has a very distinguished career, so all the hotspots of international law, and now he is in Amsterdam. He used to be at the Max Planck Institute in Heidelberg. He has a LLM from the Europa Institute in Saarbrücken, and he will speak on monetary law and human rights. And last but not least, is Werner Raza. He is the director of the Austrian Foundation for Development Research. He's an economist. He focuses on international trade and development. He has lectured at various universities. A couple of years ago, maybe it's a little bit more than a couple of years ago.
Almost 30, I would say.
Professionally met exactly when he was teaching at the Wirtschaftsuniversität here in Vienna. He has dealt with foreign trade promotion, development, finance, development policy, and he will speak on development finance. So we have an exciting panel here. I will, without much further ado, give the floor to Cynthia Nona Tamale, who's joining us online.
Thank you. Thank you so much. Can you hear me now?
Yeah, perfect.
All right, that's great. Okay, so good morning to you all. Thank you to the chair of the panel, and also thank you to the organizers of the conference for the invitation to be part of this panel. I'm pleased to be here to share my insights on the subject of sovereign debt and human rights. So I will want to discuss just briefly the context around sovereign debt and human rights. I listened to some of the presentations yesterday, and it was very insightful, but now I want to bring in the aspect of sovereign debt and how human rights considerations are what we see in having human rights considerations in sovereign debt right now. So I'll then briefly discuss some areas of cooperation, especially in the aftermath of the COVID-19 pandemic, because that has brought a lot of developments to this field. And then we'll discuss some areas of continued conflicts. There are still sites of contestation between the different actors in this space. And then, of course, some emerging areas that we definitely should look out for when we think about sovereign debt and human rights. All right, so with respect to the context, so there's some key issues that have to be stated before we have a discussion on what the areas of cooperation and conflict are. So first and foremost, as for those who participated yesterday and those who are aware about the human rights frameworks, is we have an elaborate framework on human rights. There's conventions, there's treaties, whereas when you come to the sovereign debt space, there's no sort of existing multilateral framework on sovereign debt. So what we have is mostly private arrangements, private ordering that are governed by contracts, and yet we still have to discuss sovereign debt within the context of public law, right? Because ideally this is public finance. So that's one key distinction. And that's important because when we look at human rights and the treaty protections and the obligations that come with those for states, then you compare with the ones that we have under the sovereign debt space. Particularly, we have mostly soft law instruments. So the key ones, of course, there's the UNCTAD principles on responsible lending and borrowing, as well as the UN basic principles on debt restructuring, but those are soft law instruments, and it's been the trend over the years that in the sovereign debt space there's a lot of resistance towards having stronger legislation at in international law governing sovereign debt. And the implications of that, of course, is when it comes to the conflicts that will naturally arise. When we talk about sovereign debt and human rights together, we know from the human rights space where we are speaking about having resources available to be able to meet obligations, to be able to meet the right to health, the right to education, for instance, right? And sovereign debt, we're speaking about, financial obligations of the state when you borrow, and especially when the time comes to repay those that debt. And so there's usually a conflict and a lot of tension around that, what are the priorities? So the question, what is paid first vis-a-vis what ought to be paid first, right? So in the human rights framework, we have requirements that states will not have, that there won't be retrogressive measures. And yet, when we come to the debt space, I know there's economic actors requiring that when states have debt obligations, they prioritize repayment of those obligations. And then what that naturally has led to is, states having to undertake austerity measures to be able to repay their debt obligation at the cost of meeting human rights obligations. So we have budget cuts, tax reforms, so on and so forth, right? But another key issue to note is the fact that when you're looking at human rights, we have, over the years, there have been structures for access to remedy. There's structures at the international level, the regional level, and even domestic level. Whereas when we're discussing sovereign debt, we don't even have an existing standing structure for countries which are struggling with sovereign debt to be able to restructure their debt. And that may, ideally, if one existed, then the next question would be, do they take human rights considerations into concern when trying to help countries renegotiate or restructure their debt with their creditors? So those are just some of the when you're thinking about the context, the key things to have in mind around sovereign debt and human rights. So there've been some areas of cooperation, and a key one is protection of human rights spending. So for those who've been following trends around lending, I was fortunate to have done research on IMF's lending to countries during the COVID-19 pandemic. And one thing that came out clearly was countries were being urged to, spend, but keep the receipts. But one other aspect that came through very clearly is you're going to have to undertake fiscal adjustment in the near future. And usually that's just code word for austerity measures, right? And we've seen in the latest, especially with the latest IMF programs, IMF loans, they've been the requirement for governments to protect social spending. So they have the social spending floors. Now, even more recent programs, now have governments, required to even indicate what kind of social protection programs they are going to undertake while they have an adjustment program to try and bring their debt back to sustainable levels. This is especially for countries which are heavily indebted. And so this is something definitely that human rights advocates have been speaking about, human rights scholars, from the 80s and the 90s when we had the structural adjustment programs. When you're doing all these economic reforms, there has to be a consideration for human rights. And so to one extent, you could say that because there is a push for this. We could go further and discuss the extent to which social protection flows are helping, but it is definitely an area of cooperation. And another one, of course, is the increased accountability mechanisms for human rights, especially in lending projects of multilateral development banks, as well as international financial institutions, just mechanisms to ensure that human rights are protected in these projects. Now, of course, this has been a result of a lot of pressure from scholars, from civil society. But there is, while it's an area of cooperation, it's important to note that this is a trend that's mostly with the bigger institutions, the recognized development finance institutions, so the multilateral development banks. We don't necessarily see this trend with other lenders. So for instance, with private lenders or with the other categories of lenders, I'd say maybe even the bilateral, that there's a requirement that they should be thinking about these considerations. So that is definitely one key issue. Another one is, and very important for human rights, of course, is the issue of debt transparency and accountability. So there seems to be more agreement between the economic actors as well as human rights actors around the importance of debt transparency and accountability. However, there are still issues. So there is an agreement on principle. The question is how it's being implemented, and there are still a lot of issues around which creditors actually publish information or allow for the information to be published around debt contracts, because that's important for human rights, for the citizens to be able to keep their governments accountable, or to even know the extent of indebtedness of their governments. Another key area where there's been a lot of cooperation, especially in the COVID-19 context, post-COVID-19 period, has been the issue of debt relief. Now, debt relief is, of course, very important for human rights, because when a country is struggling with a heavy debt burden, typically then most resources, and this is a trend that we're seeing, especially in a lot of African countries, where a lot of resources, a lot of revenues are being channeled to repayment of debt. And so what that means is that without debt relief, then countries don't have sufficient fiscal space to be able to meet their other needs, other investments, including investing in human rights. And a key example was the World Bank came out very strongly in the restructuring of Chad. Chad was one of the countries in Africa that was indebted. And went through a restructuring process, and unfortunately there was hardly any debt relief. And so it was really surprising, but also encouraging to see that it was actually the World Bank that came out to criticize the process and say, there's no way a country has gone through debt restructuring for this many years and does not have any relief. So it's encouraging to see that some of those areas of cooperation, especially on the need to support countries that are struggling with heavy debt. Now, when we come to the conflict, I think to answer the question, the theme of the conference, I would say there is still a continuing conflict, and these are some of the sites of contestation. First of all, the language of human rights. There's still a lot of resistance, especially among economic actors, with the language of human rights. And this I noticed from my practice, where there's just, yes, they will recognize that it's important that countries have the space to be able to invest in their SDGs, the language that we use, for instance, but we hardly see human rights, recognizing human rights as law and the requirement for governments to also protect their human rights while in their lending arrangements, right from contraction of debt to repayment of debt. So that is something that is definitely still an area of contestation. Another one, of course, is around transparency. So while in principle it's agreed, in practice there's still a lot of opaque lending, especially around the terms of lending. There's still confidentiality clauses within lending contracts, and there's been a lot of studies done around this, including on Chinese lending. And there's, of course, a conflict with human rights obligations where, we're required to have, if people should participate in these decisions, then they need to have the information. And so that is definitely still an area of contestation. Commercial law practice, economic, the different economic actors still insist that there is need for confidentiality, while, on the human rights front, that is definitely will definitely shut out participation in lending decisions of countries. Another key area, of course, is the assessment of debt sustainability. Now, this is something that is done predominantly by the World Bank and the IMF, and they have the debt sustainability framework, one for the low-income countries, and a different analysis. Another tool is used for middle-income countries or market access countries. Now, the main challenge is that the way that debt sustainability is assessed is that it's mostly hinged on economic indicators. How will the government be able to repay the debts that it has borrowed? So the indicators are framed around repayment of debt, whereas which means, and to a large extent, then we don't consider the human rights aspects and the human rights indicators, which would, of course, mean if a government is borrowing, can it afford to borrow based on how much it is investing in its human rights obligations? So if we were to take, for instance, the health sector, education spending, social protection spending, and that has been a criticism that has been weighed against the IMF and World Bank debt sustainability tools for failure to be able to incorporate human rights considerations in the way that debt is assessed. And so countries are then allowed to continue borrowing, even when it's clear that they can't afford it, because majority of their revenues are going to debt servicing as opposed to investing in their countries. And then, of course, the issue of reform of the global debt architecture. I know this is something that has also been discussed from yesterday, and looking at it from the human rights framework is that because there's no structure, existing mechanism, and no existing multilateral framework governing it, then that means it's really left to private arrangements. And so you have countries with a low bargaining power trying to get to the table with creditors and without any mandatory measures. And it seems it has, over the last few years, demonstrated that this is something that needs to be reconsidered. Most importantly, the importance of having all creditors on the table. So even with the measures that we have now, for instance, in the post-COVID pandemic era, the G20 countries came up with a common framework for debt restructuring, but unfortunately, only bilateral creditors are restructuring their debt under that framework. The multilateral creditors have argued that they are more superior creditors and their debt needs to be repaid fast, but also that they are continuing to lend to countries in debt crisis, while the private creditors have not pretty much coming to the table on a voluntary basis. And if they do not, then it's the countries that are shouldering this burden. And that automatically means that if they're continuing to receive debt payments at the detriment of human rights obligations of indebted countries. A few last issues, of course, is the question of fiscal adjustment, aka austerity. And this is definitely from looking at the different countries that are currently restructuring their debt under the G20 framework. All of them are African countries at the moment. Some other countries have opted not to go through the framework because of some of the challenges, and are instead restructuring directly with their creditors. And the main challenge, of course, with this is the primary prescription is, austerity. Cut expenditure cuts and revenue reforms. Now, of course, of late, including as in 2024, the IMF's position in one of its recent papers was that they prefer that countries go for revenue measures, and in this case, hopefully progressive revenue measures, than expenditure cuts. And that would be, of course, a really big step forward away from the expenditure cuts that have been affecting human rights, investment in human rights for so many years. But for what continues, though, is that there's the idea, it has been embedded, that when a country is indebted, then the prescription is austerity, so until it can get on the right path. And there's been proposals for alternative ways of supporting countries which are shouldering heavy debt, but we're yet to see there's reform proposed reform of the debt restructuring, of the debt sustainability framework by the IMF this year. So we wait to see any outcomes from that, but that remains an issue of contestation, especially with respect to human rights. Lastly, the issue of compliance. Now, we all know on the human rights front, there's clear indications of when human rights violations have been, what needs to be done, and the avenues available for human rights violations. Whereas on the debt side, that there's also the consequences of debt defaults, which include countries not being able to borrow, countries losing market access, and the implications of that. And so we find that even with stated consequences of non-compliance with human rights obligations, the scale definitely tips more towards the fear of debt defaults. And so you find countries that are definitely spending much more on repaying debt and undertaking measures to ensure that they are able to repay debt at the cost of meeting human rights obligations, or even undertaking retrogressive measures to be able to repay their debt. Now, lastly, in just a few minutes, some of the key emerging issues, which I think are going to be very interesting to look out for going forward with respect to this sovereign debt and human rights relationship, is of course the question of sustainable finance. Now, this is finance that ideally should be used for environmental and social objectives, for instance. And one key example, for instance, would be the thematic bonds, the green, social, and sustainability bonds. The way they are being marketed is they are going to be avenues for countries to be able to borrow for specific objectives. So environmental objectives, social objectives, sustainability objectives would include investing in, for instance, health and education, which would be great for human rights. But the bigger question is, what are some of the key challenges that could be posed by countries borrowing more under these kind of things for human rights obligations? And then who is tracking? Are there human rights indicators to measure how, to the extent to which this debt is actually realizing human rights obligations? What happens when countries default on debt that they borrowed for social objectives? Those are some of the questions to be asking. I think another key issue is the issue of accountability. With the other lending mechanisms, especially with the IFIs, we have structures for accountability where human rights violations occur. But when we have a bond, for instance, where we borrowed from private actors, and then you have a project and there's violations, then there's questions around who is going to be accountable. And there's a lot of work that's been done by scholars, including Professor Celine Tan, who has written extensively on these issues. So these are some of the things to look out for. Lastly, creditor composition. Of course, that is important. The number of creditors is just increasing. There's a multitude of creditors involved now beyond the traditional lenders that we knew. And so that definitely makes it even more complicated, the debt resolution process even more complicated. And then, of course, because of that, then we have challenges around being able to protect human rights spending for countries which are indebted if we don't have an existing debt restructuring mechanism to be able to bring all the creditors on board to support a country that is struggling with heavy debt. All right, I'll stop here for now, and I look forward to hearing from the audience, but also to hearing the presentations of the speakers. Thank you.
Great. Thank you so much, Cynthia. I think that was a very good introduction, and I'm sure there are many questions immediately, but since we're running on a tight schedule, I suggest that we hear first all the three presentations, and then I open up the floor for discussion. So next, I invite Kanad to speak on the IMF and monetary law and human rights. You want to speak from here? Yes, sure.
Thank you very much for turning up today morning. And thank you also to the chair for the lovely introduction. So what I am going to do is going to take you through a little bit of history on international monetary law and human rights. And I will do that for two reasons. One is that we've heard a lot of conversations yesterday about how issues related to human rights, sustainability, inequality, poverty, and so on and so forth have become important today, right? Have become important today when we deal with international economic law. But I would argue that concerns related to human rights, whether we like to call it development, inequality, employment, poverty alleviation, are not of a recent or a new iteration, but in fact have been in discussion and within discourse for a long time, and at least going back until the Bretton Woods system, right? What you have here is a speech by this person from the executive board of the ECB, and look at what is being said here. It's a pleasure for me to join you, of course, and in my remarks today, I would like to discuss an unusual topic for central bankers, namely the interaction between monetary policy and inequality, right? All economic policymakers have some distributional impact, yet until relatively recently, such consequences have been largely ignored in theory and practice of monetary policy. So this suggests that central banking and monetary policy and human rights, right, do not always and have not always had a relationship. But it's only now that this relationship has come to the fore. Another consequence of this thinking is that we tend to look at human rights and central banking and monetary law as exception to an otherwise normal rule. The normal rule is that central banks and money has nothing to do with human rights. Why? Because money is considered to be a neutral instrument of economic control. Human rights is political and social, and therefore best left to governments and parliaments. Central banks should not be concerned with human rights at all. And you see this kind of thinking also coming in through the same speech. It is said, of course central banks are not charged with addressing inequalities. Of course. Right. But it's become important today to deal with such things. And in pursuance of that, you have a number of studies from different institutions. You have, of course, the IMF. Then you also have the Bank of England, and so on and so forth. Other central banks coming up with studies more and more today, showing how central banks need to take human rights seriously. Right. But I would ask you to pause. My claim to you is that central banks, monetary law, and human rights have a much longer history. And this history is messy, contradictory, and uneasy. Right. Now, we all know about the Bretton Woods system, established in 1945, where you had an agenda for economic governance after the World War II. Now, one of the characteristics of the Bretton Woods system, and at the heart of it, was the idea of development. How do you ensure economic development for the countries after the war, but also for the third world? Right. And in this agenda of the Bretton Woods, central banks were supposed to play a very important role. Monetary policy was supposed to play an extremely important role. It was understood that money and central banking, right, were to be crucial towards addressing concerns of economic development, inequality, poverty alleviation, and so on and so forth. Central banks at that point in time were doing so many different things. It was intervening in financial markets. It was investing in local development banks, creating capacity. Central banks were important in pursuing policies related to credit creation, for instance. Things that we do not associate with central banks anymore, right? So Gerald Epstein, which you see on the left, characterized central banks at that point in time as agents of development, right? Highlighting how money was an important instrument for redistribution between capital and labor, the age-old struggle, right? Money was supposed to balance that scale between the asymmetry of power between capital and labor. And it was to be done through central banking and monetary frameworks. So I call this period of Bretton Woods a period of strategic entanglement of monetary policy and human rights, where these two were inseparable. One could not think of economic policy and central banking and monetary policy without thinking about human rights considerations. right? But something changed. Something changed in the 1970s. We had the fall of the Bretton Woods system, right, of fixed exchange rates, but we also had this tremendous period of stagflation, that is, rising inflation and rising unemployment at the same time. And it was at that point in time that a new monetary orthodoxy came into being, led by central bankers like Volcker. We have probably heard of the Volcker shock, or the Volcker shock doctrine, right? So when he took over, so when Volcker took over the Federal Reserve, the idea was that, well, we need to restructure, we need to rethink central banking entirely. And from the 1970s onwards, the monetary consensus became that central banks should do one thing and one thing only. They should focus on price stability, that is the control of inflation, and they should be independent from government. So central bank independence. Price stability and central bank independence became the reigning doctrine of that time. And from then on, the idea was that central banks will not do anything else. They will not be concerned with employment. They will not be concerned with development, poverty, and so on and so forth. They will only be concerned with the stability of money, making sure that inflation is low and under control. What happened as a result was that central banks, which were considered to be highly social and political institutions during the Bretton Woods era, became a technical institution, a neutral institution, a apolitical institution. There was a scienticization of monetary policy. There was a separation. There was a separation, but also, in some sense, a co-option of human rights and central banking. Because 1970s, interestingly enough, was also a time when the human rights language and framework began to surface. Right. The 1970s was the hallmark of international human rights agenda. You had the ICCPR, ICSER, the United Nations human rights committees were in place. And these are some of the books which really trace that rise of international human rights framework. Right. And the idea became that the only way central banks will be able to fulfill human rights obligation was through the mandate of price stability. That if you keep your prices stable, everything else will follow. That was the idea. And therefore, human rights, in some sense, a very narrow version of human rights in some sense, was sort of co-opted by central banks and monetary law. And therefore, I call this period strategic co-option. So from strategic entanglement, we have reached strategic co-option. Now, by the 1990s, central banking became a priesthood of itself. Central banks were considered to be priests of prosperity, right? Why? Because they were successful. They were successful in ensuring that inflation was under control, right? And as a result of this priesthood status, they started becoming more and more disentangled from governmental agendas of human rights and development. And this also happened institutionally. So central banks started meeting within the Bank for International Settlements. But the human rights agenda was taken to the United Nations. So there was an institutional separation as well in terms of where would central bankers go, where would the agenda for human rights be discussed. And the Bank for International Settlements, for those of you who do not know, is in fact the oldest surviving monetary institution that we have. It's one of the closest in the sense that it is hardly open to the public in terms of what goes on inside the bank. You would have heard of this Bank for International Settlements in the context of the Basel regulations, 1, 2, 3, and now 4, with respect to capital adequacy ratios for banks. But the Bank for International Settlements does a far more important work. It's a forum where central bankers come together and discuss how monetary policy is to shape up in the years to come. And that is completely removed from public view, right? So there was an institutional separation. 1990s, 1980s would be that time, right? And I call this strategic estrangement. Estrangement between monetary law and human rights framework. Right. Now, things dramatically also changed after the global financial crisis. A couple of things came to the fore. First, it was clear that central banks were not really priests of prosperity as one thought they were. Second, the neutrality of monetary policy was questioned. Right? Central bank independence was questioned, monetary neutrality was questioned, and it was shown how central banking and central banks were actually making very crucial distributive and allocative choices. They were buying bonds. They had the choice over what bonds to buy. They were taking bonds as collateral. Which kind of bonds? There is a lot of research that much of the bonds that were serving as collateral were bonds from companies which were highly carbon intensive. So central banks, in no sense, were acting in a neutral fashion. Money was never a neutral instrument. Now, as a result of this, the legitimacy, to some extent, of central banking came to be questioned. Right? And there was a repoliticization of monetary policy, in the sense that demands were being made from civil society and other organizations that central banking must then take into consideration the distributive impact of their policies. They must take into account how their policies affect wealth and inequality, and wealth inequality and poverty and other indicators. In other words, how their policies must take into account human rights. Right? And as a result, what we have today, and we come back a full circle, is that the IMF, central banks across the world, have come up with their own agendas of how this alignment must happen between central banks and monetary policy. Right? So you have papers after papers now discussing how central banks should align with the climate change agenda. You have papers about how central banking should now focus more on inequality, as we saw in the previous slides. So in some sense, we have come back a full circle. Right? A recap. So what did we... It was a long period of history that we covered in 15 minutes. So we had the period of strategic entanglement, where human rights and monetary law were necessarily entangled and together, and one could not think of one without the other. Then you had the period of strategic co-option, where central banking co-opted a very narrow version of the international human rights framework that essentially was about preservation of money, so price stability, which meant a preservation of property in some sense. From then on, we moved to a strategic estrangement where central bankers institutionally separated themselves from the human rights agenda, which was mostly being taken up in the United Nations, but central bankers went to the Bank for International Settlements. And finally, we come back a full circle, where now, after the global financial crisis, there is again talks of an alignment between human rights and monetary policy. Now, why go through this history? Right. The reason I argue that we need to go through history is because, number one, to sort of dispel the myth that questions of sustainability, human rights, and so on and so forth are of a recent iteration in central banking and monetary law. No, they have been major sources of contestation, major sources of discourse throughout periods of history. Right. The change, however, is that today there is a realization within the mainstream circles that monetary law and monetary policy is simply not about economic governance, but it's also crucially related to power and politics. Right. So my proposition to you is that I don't think advocating for more human rights, mainstreaming human rights, as we saw in the panels yesterday, is going to cut it in any sense. What we should rather be doing is to see how central banking and the orthodoxy of monetary policy, which proposes price stability and central bank independence as the model, needs to be questioned. So how internal frameworks of how central banks work should be our query and objective, right? And we must ask the question, stability for whom? Human rights for whom? Because none of these questions address a homogeneous sort of a structure, but we are always talking about different interests and communities, right? I will stop at that. Just to put it out there, if any of you are interested, I talk about some of these things in this recent article of mine. It's open access. You can go through it. Yes, I'm also looking forward to the questions and comments. Thank you very much.
Thank you very much, Kanad, for giving this overview of the history from entanglement to alignment, and how considerations of human rights and development have formed in the past and probably should form today a central strategic consideration for monetary policy. And again, I'd ask you to bear with us now. I ask Werner for his presentation, and then we go into a debate.
Okay, so thanks a lot for the invitation. It's a pleasure to be here. To be honest, before the conference, I was a bit skeptical if I'm really capable of addressing an audience of human rights lawyers, legal scholars. Since I'm not a legal scholar, I'm an economist, but Holger convinced me that this might make sense. And after the last presentation, I think there is obviously a lot of overlap between economists and international lawyers on all of these topics. So I'm going to talk about development finance and human rights. And I'd just like to make clear that, there's a difference between development finance and development cooperation. Development finance typically relates to bank-based lending at however subsidized rates. Whereas development cooperation basically is operating on the basis of grants. So I'm not going to talk about development cooperation and human rights, which would be also quite an interesting topic, obviously. But I'm going to concentrate on development finance, and development finance is basically a process where a bank, be that a public bank or a private bank, extends a loan to a party in what is called developing countries, less developed countries, low-income countries, all these kinds of expressions for the global south. So basically, I'm going to talk about how gradually and through a contested process, human rights became part of development finance and became, to some extent at least, integrated in the procedures of bank lending. That's basically what I'm going to talk about. So, overview, I'm going to focus on the industry benchmark, so to say, and that is the World Bank safeguards, which come in different variations, and I go through the history of the World Bank safeguards and the IFC performance standards, and try to explain how that was gradually implemented into bank procedures and what the effects and problems of doing so have been over the last more or less 3 decades. So the story more or less starts at the early 1990s and goes then through to our contemporary period. Okay, so the interesting thing is that when we talk about human rights and their implementation in development finance, we are not talking about a process, a political process of international norm shaping, international cooperation in terms of agreeing on certain international standards. It's more a process that kind of crystallized around the World Bank and its lending practice, particularly during the 1980s, because the bank, and it is one of the institutions of the Bretton Woods arrangement, the bank has, through its various lending arms, particularly through the International Bank for Reconstruction and Development, which is basically the lending arm of the World Bank Group towards the public sector in the Global South for infrastructure financing, basically. Large-scale infrastructure financing, large-scale also industrial financing, etc. So through the activities of the World Bank in the 1980s, there came to be an awareness that that kind of lending led to harmful impacts on the environment, on local populations, on the preservation of cultural sites and all, and similar topics. And it was basically social movements in the Global South, also civil society groups in the Global North, that started to question these impacts and started to criticize bank lending practices in terms of not accounting for the impacts of their bank lending. And the World Bank then basically had to react, and it came up with a first set of what came to be called safeguard policies, basically in the early 90s. And these kinds of safeguard policies became then gradually extended in a more or less contested process that basically goes up to the present. So what we then see is that after these World Bank, the first version of these kind of World Bank safeguards was established, also some kind of an accounting mechanism was introduced in the World Bank, the so-called inspection panel in 1993. And the interesting thing is that what the bank implemented became some kind of a role model for many other international lenders. For other multilateral banks, the Inter-American Development Bank, the African Bank, the European Bank for Reconstruction and Development, the EIB, etc., it was also, in a second step, transposed into the national legal systems of many emerging and developing countries. And via its private sector lending arm, the IFC, the International Financial Corporation, the World Bank safeguards became also the role model for private sector lending. So the IFC basically developed its own version of the World Bank safeguards, which came to be called performance standards. And these performance standards became then the industry benchmark for all the private sector lenders. And these are commercial banks, for example. These are development finance institutions, for example, the European development finance institutions, the Austrian Development Bank, for example. They also apply the performance standards. And also, they became the role model for the OECD arrangement on export finance. So the interesting thing is that export finance is kind of institutionally mediated and governed by a separate institutional framework that is hosted by the OECD in Paris. And that arrangement, so-called arrangement, also developed its own human rights standards, if you want, safeguard policies, on the model of the performance standards of the IFC, and that's called the common approaches. So this is more or less the process, and the performance standards became then very, very important also for the commercial banks that lend to parties in the Global South, and were instituted in what has been now called, or came to be called, the Equator Principles in 2003. Nevertheless, through all that process, obviously there was a constant discussion between the World Bank, other international banks, commercial banks, and civil society and social movements in the Global South, given that it became increasingly clear that the application of those performance standards or safeguard policies in practice on the ground is quite difficult. It's quite difficult to really, put them on the ground, say what does it specifically mean if you apply, say, the World Bank safeguard policy on indigenous peoples and their rights. And that led also to a gradual extension of the framework over the time. So we see various revisions of both the performance standards and the World Bank safeguards. In the 2000s, for example, so there was a revision of the performance standards in 2006, another one in 2012. And we also have, and that's quite significant also in terms of human rights, We've had a major revision of the World Bank safeguard standards in, between 2012 and 2016, so that in 2017 a new environmental and social framework entered into force. Okay, so when we talk about the World Bank safeguards, what are we talking about? What is the scope of these safeguards? Here you see basically that they contain 3 elements: operational principles, which state the policy objectives and also the operational principles, including the roles of the bank and also of borrowers. Then you have a set of procedures which are mandatory and have to be followed by the bank, but also the borrowers. And then you have, all kinds of good practices which play an advisory role. And in substantive terms, the safeguard policies are more or less split into 3 segments: environmental policies, social policies, where I would argue the most straightforward relation with human rights comes up, particularly with respect to involuntary resettlement and the rights of indigenous people, and some legal policies. That basically means the scope of the human rights is restricted to certain economic, social, and cultural rights, and not civil and political rights. I think that's important to keep in mind. It is a selective approach. So what are then the key, if you want, procedural principles? Well, the whole thing is basically a risk assessment exercise. So once you go to the World Bank or some other development bank and want funding for a project, the bank will make a risk assessment and a categorization. And basically, if, say, the project is expected to have severe impacts in environmental dimensions or in social dimensions, it will be rated as an A project. If it has specific, less profound impacts or expected impacts, it will be rated B. And if there are no, kind of negligible effects to be expected, it will be rated C. And then there's a whole, focus on, if it's an A project, what can we do to mitigate certain harms, certain impacts. And that will be the focus, basically, of the assessment procedure then. And if it's not possible to mitigate all the effects, but certain effects have to be expected, what will be, feasible remedies, compensation, for example, for resettlement and similar things. There is some kind of accountability dimension in that risk assessment procedure via the inspection panel for the IBRD and IDA funding. There's a second accountability mechanism set up by the IFC for IFC and funding and MEGA guarantees. So accountability mechanisms, and there will be some kind of monitoring procedure, then also attached to the lending contract with the borrower. So that's the procedure, and that procedure basically, has become the standard for the whole industry. Also, basically, commercial banks and many other multilateral, bilateral development banks apply that process. So what are then the instruments to safeguard certain, or to kind of mitigate impacts, to remedy impacts? So typically, you do all these kinds of exercises. There will be a sector assessment or a regional assessment. There will be an environmental assessment if there are to be expected profound environmental impacts. Then there will have to be elaborated environmental management plan. That is a plan that envisions certain remedies, certain instruments that need to be applied to mitigate environmental harms or to manage environmental harms. There will be a resettlement action plan in the case that there will be resettlement of local populations. There might be a plan for affected indigenous peoples. There might be a best management plan in case of certain environmental hazards to be expected, and also a dam safety plan in this particular case of a dam project. That basically has led to processes of large infrastructure projects to be very, time-consuming, involving many, many different parties. Also cost-intensive, because all the costs for these assessments have to be borne by the borrower. It's not the bank who's going to pay for that. And obviously, what has been another consequence is the emergence of a large consultancy industry, because all these assessments are typically done not by bank staff, but by private consultants who are specialized on certain aspects. So the process has become quite time-consuming, and actually my qualification for talking about this is that I've been sitting on advisory boards of the Austrian Development Bank, and also of the Austrian Export Finance Committee, and I've been involved in these kinds of processes for many years. So that has been one of the consequences. So all of these projects have become quite time-consuming. Okay, so there's this ex-ante assessment in terms of the process. Then the bank determines the assessment procedure and the application of specific operational guidelines. The applicant has to supply all the required information and pay for it. The bank decides whether to provide funding or not. If the bank says yes to funding, the bank can require certain conditions to be made or to be met by the borrower. So it can require the implementation of a resettlement plan. It can require the implementation of an environmental management plan, etc. The point is here, the leverage of the bank to require all these things basically is only possible during the duration of the funding contract. Once the money has been paid out and the project is implemented, the leverage of the bank basically has become very low. That is, one of the big criticisms and also, practical problems. You can set up certain conditionalities, but once the money is gone, and you have a government as the borrower, for example, your leverage is limited. Okay, so we've had all these kinds of, procedures that were implemented, say, from the early 90s until the mid-2000s. Nevertheless, obviously, when you talk about how that is really implemented on the ground, how the standards are applied, all kinds of practical problems come up. So to just give you an example, I was involved in advising the Austrian government on a dam project in Turkey, a big dam project in eastern Anatolia. We made missions there, talked to people on the ground. And there was resettlement, obviously. 40,000 people had to be resettled because of the flooding of the area because of the dam. So there needed to be a resettlement plan. So what does it mean when you resettle people? Well, the idea is you have to compensate them somehow. Yeah? What does compensation mean? Yeah? So people are losing their houses, for example. Farmers are losing the land that they labor on. Yeah? So the practical problems that emerge are, for example, that, okay, people are offered apartments. And these apartment buildings are not constructed near their original living area. They are constructed 50 kilometers away at the outskirts of the next larger town. These are new buildings, but they are not houses. Farmers have houses with gardens. So they are offered an apartment 50 kilometers away in an environment they don't like. The government says, okay, most of these farmers, they live on land that is not their legal property, because either it's owned by a landlord, a rich person, a landlord that lives in the city, and the houses they live in are also owned by that landlord, so they don't have a legal title. Or even if they have a legal title, the value of the house and the land on the countryside in eastern Anatolia is very low. The value of the new apartment at market value in the city is quite high. So there was a discussion of whether these values are equivalent, or whether the affected local population basically runs up a debt against the state in moving into these apartments. So that has been one problem. A second problem is that either most of the farmers in that area, for example, either they worked on land they didn't own because it was owned by a landlord, or they thought they were working on their own land, but they didn't have a legal title to the land because it was, they worked on customary law. It was a Kurdish population. The state came in and said, okay, you don't have a legal title. you have worked that land doesn't belong to you. It is basically the land of the state. So if there's no legal title, if there's no landlord, you have to prove to us that your title to that land is legally recognized. And that basically depends on the existence of a land registry. In that area, there was no land registry. So the affected population didn't have a legal title. So these are all kinds of, and then the question is, how do we deal with that? Yeah? And what kind of compensation would you think is appropriate? So these people are then relocated from the countryside to a city. They've been farmers. They lack the skills to take up another occupation. So then the question arises, okay, will you give them, skills training? Will you offer them skills training? Will you offer them, say, a loan of 5,000 or 10,000 euros to set up another business in the city? For how long that support will be provided by the government, etc., etc. So all these kinds of practical implementation problems pop up when you deal with these kind of relocation issues, and there are no clear-cut standards for doing that. Just compensation is the standard. It can be debated quite controversially what constitutes just compensation. Okay, but that's just by way of illustration. So now we are moving into the 2010s, and as a consequence of a growing, on the one part, of growing civil society resistance against that kind of application of those standards, and the criticism that the practical applications of those safeguard policies did not really constitute just compensation and did not really safeguard human rights, there was another discussion coming up in the 2010s, both within the framework of the World Bank, but also more generally in development finance on how can we cope with that? What kind of additional measures do we have to introduce? What kind of human rights aspects are still missing? For example, labor rights, or health and safety at work, or the rights of women, of vulnerable groups, etc. And on the other hand, there was a geopolitical change with a larger role of emerging powers and their development finance institutions. So, for example, the Brazilian National Development Bank, BNDES, it's much larger than what it had become by that time, much larger than the World Bank. Also, the Chinese export finance banks became much larger. They did their own thing, basically. They were not part of that World Bank-led human rights safeguards framework. Then the emerging powers set up their own kind of multilateral institutions like the Asian Infrastructure Development Bank or the New Development Bank set up by the BRICS states. So there was this kind of problem that all these new banks and institutions did their own thing, did not really take over this framework that was developed by the World Bank and by the, if you want, Western development finance community. So there was this four-year reform process with lots of public consultations, contrasting positions. On the one hand, no dilution of existing safeguard policies and introduction of new standards, for example, for human and labor rights, versus more flexibility and autonomy for the borrower states, because China and others said, we do not feel bound by the World Bank safeguard policies. So the result was a new framework after 4 years, an integrated framework with 3 elements: a vision statement, a new set of environmental and social policies, and then standards, 10 environmental and social standards defining the duties of the borrowers. So when we look at this environmental and social commitment plan as the new basic instrument in that new framework, that plan stipulates all the rights and obligations of the World Bank and the borrowers in one document, and it has 2 main new elements. There is an extension and intensification of the bank requirements for the implementation phase of the project, and that relates particularly to more rights for affected stakeholders and also the establishment of project-specific grievance mechanisms. I told you before that there are certain grievance mechanisms, but they are institutional grievance mechanisms, they are not project-specific mechanisms. And there was the introduction of an escape clause, and that basically meant that the borrower, if it's a government, can determine whether it wants to apply the World Bank safeguard policies or whether it wants to apply its own national standards. And that was a compromise that was necessary so as to convince China, Brazil, India, and other emerging powers to agree to that new framework, given that it's, a World Bank framework, and they are sitting on the board of the World Bank because they are members of the Bretton Woods institutions. So it was important for the World Bank to have those new actors participate and agree to the new framework. Otherwise, there would have been a split, an open split. And that was something that the bank wanted to avoid. So basically, it was a compromise, this new framework. Nevertheless, human rights play a larger role in that new framework. There is an explicit but non-binding reference in the vision statement. And the rights of affected individuals have been strengthened in the new framework. And that relates to meaningful consultation, that relates to the establishment of minimum standards for the protection of workers, and also a ban of child labor in bank projects, and some other issues, particularly also to the requirement for free, prior, and informed consent for affected indigenous peoples. Free, prior, informed consent was not a strong standard in the previous safeguard policies. Nonetheless, it's still a fragmentation that might be interesting for you as lawyers. The bank basically decides upon its own how it interprets all of these standards. It is not bound by any other international human rights fora. In doing so, there might be some kind of peer pressure, but there's no legal requirement for the bank to do that. Okay, so that brings me to the conclusion. The interesting thing is about development finance and human rights that it has been the World Bank who has been the norm shaper. And the idea was to provide something like a level playing field for both public and private development finance. And then, through a contested process, that level playing field was gradually extended. But nevertheless, we're still in that kind of contested area. On the one hand, development finance institutions, they want to fund projects. It's their business. Yeah? So they have an interest in doing that. On the other hand, to take care of these human rights impacts is a burdensome process for the bank. It is burdensome for the borrowers. So there is this tension going on structurally present in that field of activity. Nevertheless, there has been some progress. The question will be whether the large emerging powers like China and others, whether they buy into that new framework or whether they opt out through this escape clause possibility that they have. And the third point is, nevertheless, I would say, with that compromise, if you want, the World Bank's epistemic authority and norm-shaping capacity was at least partially retained. And I would have said, given the geopolitical framework, it would have been also a real possibility that the whole system would have more or less become fragmented and different actors do different things in the system. Okay, so thanks a lot for the attention. Looking forward to the discussion.
Thank you very much, Werner, for this fascinating insight also into the details and consequences of development financing when it comes to the effects on the local population. I now open the floor. Any kinds of questions to all the three of the presenters here? We have a microphone. Yes, please. If you could very briefly identify yourself and then also say to whom the question is addressed, if to anyone specifically.
All right.
Please.
Thanks very much to all the presenters. I'm Katja Kalkschmidt. I'm a development economist in-house. So I'm happy for that session. And I have one short question for each of the speakers. So I'll begin with the first speaker, which is Cynthia. Cynthia, can you one more time tell us what these GSS bonds are about? I somehow have a lack of understanding how I should fit them in. So we have development finance divided in aid finance and debt finance. Debt finance more for production infrastructure projects on an economics view, more towards using like market rates of interests. And we have for social infrastructure projects like aid finance that comes with more concessions. So what are these GSS bonds for? Shouldn't they be aid? Shouldn't this be aid finance? To Kanad, there's one thing I agree and there's one thing I don't agree. For the don't agree, I hope you can convince me. So I agree that the excess usage and printing of money has never been something that was neutral. That for sure not. What I really don't see is actually, I think, at the core of your presentation, which is this full cycle. I really don't see the full cycle. I really don't see that the central banks have ever had something else than a narrow scope of human rights. I see that there has always been like three functions in that you partly manage. So we manage price stability, that has become more and more nuanced later. We also had always economic growth, sustainable, constant growth in it. And we had deciding on some kind of exchange rate management or exchange rate regime depending on our interests on monetary policy autonomy. But so the scope of human rights was, which I would see in there, like indirectly, would be coming with economic development and growth, which would be average growth. And I don't, never explicitly tackled inequality or just growth, that I would see. Maybe you have more information, can you get in that? And other than that, these two dimensions of human rights, rights to economic prosperity and eventually equality, where are the other aspects of human rights that you would have seen that has been there before, then somehow vanished and come back again? I really don't see the cycle. I see more like a line, a one-direction line, which might not be a linear one, but non-linear one. Maybe you can get up on that. And first, Werner, so I'm closer to you as a development economist. So my question is more of a practical one. Do you see that with the introduction of the ESF, that the portfolio of borrowers has changed? So is it different countries, is it different projects that are now applying for, that are granted these projects? And do you think that this presence of alternative from China, from India, has contributed for these clause to draw back on national law in order to not, lose a footprint or foothold on that? And related to that, do you see that there's more of a cooperation or competition between the different finances, especially the one from the West and alternative to the Western approaches? Thanks.
Thank you very much. I would suggest that we collect a little bit. Please, you're the next one. And yeah.
Okay, that was a lot of questions. So, so I have, again, apologies. I have two questions.
Identify yourself very quickly. Yeah.
Thank you. I'm Dr. Shiva Thambishetty from the LSE, and I spoke yesterday on IP and genetic resources. So I have two questions, and one question specifically for Dr. Cynthia, and the two questions may also apply to the other speakers, so I'll leave it to you whether you have something to say on that. Dr. Cynthia, I don't know if you've been following the pandemic accord negotiations. At one point, the African group suggested that a debt swap would be a financing mechanism under Article 20. That argument seemed to wax and wane during the course of the negotiations. There was acceptance that it would be taken on board as physical constraints. I'm not sure what final term, if any, has been retained in what was agreed yesterday. But do you have any views on whether that would, it's a good idea, it's feasible, it sounds good, but I'd love to hear from you on what, on those thoughts, and also generally about these sorts of treaty financing mechanisms, if the other panelists have anything to say. And my second point, when I was listening to, I loved the presentations, was the role of philanthropy in each of your topics. Perhaps there isn't any, but are big ticket philanthropists moving the needle in any form, against, for? That would be good to know. Thank you.
Thank you. And we have a third question, Werner Stutz.
Thank you. I also have three questions. To Dr. Cynthia, I have a rough idea of what this bonds for sustainability would look like, but maybe you can expand a little bit on how human rights bonds would work in practice. To what extent would debt be forgiven, and for what kind of human rights deliverables? You also talked about creditor composition as a factor that might complicate matters. Is this a matter of diversity of creditors, or that their interest is simply repayment? Can you expand a little bit on this? And then to Mr. Kanad, you talked about the orthodoxy that is given up on monetary stability. The orthodoxy would be that especially poor households that have to dispense a larger proportion of their income will benefit from price stability. Now, there was a lot of quantitative easing during the pandemic, but that hasn't led to redistribution and more equality. What would it take? I mean, what would central banks have had to do in order for that to happen? And my last question to Werner Raza, you mentioned about the opting out of BRICS countries. Now there's this new BRICS bank, mainly Chinese financed. What would they do in terms of conditionalities or in order of environmental, social impact commitments? They were talking a lot. They would focus more on development, whatever that means. Do they have any alternative systems to offer, or are they simply operating as a classic bank, focusing on repayment? Thank you.
Okay, thank you very much. I think that's a full load already of questions. And if I may invite Cynthia first to give us some responses.
All right, thank you. Thank you for those questions. I'll discuss the questions on the bonds first. So the first question was just to discuss more about the GSS bonds. So just an acronym for green, social, and sustainability bonds, which fall under the broader category of sustainable bonds or thematic bonds. And in summary, what these bonds are meant to do is to help issuers, who could be governments or companies, to get funding for specific objectives, right? So typically it would be for environmental and for social objectives. So the ones which are the most common, of course, are the green bonds. But of late, we're seeing also some countries taking up social and sustainability bonds. And the way that they work is that there will, of course, be specific use of proceeds clauses. So the governments will indicate what the proceeds are going to be used for. So a social bond, for instance, which is meeting social objectives, would be expected to meet for social development. So that would be, for instance, health projects, education projects, name it, while a green bond per se would be talking about how to conserve the environment, or a variation of a green bond with blue bond, which would be for ocean conservation, that sort of thing. Now, the issues that come about when you think about those types of bonds with debt is, as these bonds are coming up, there's several questions to ask. Number one, what does enforcement of those bonds look like? So this has implications for human rights for two reasons. One, how do we actually, what are the measures in place to actually assess whether the funds that are being collected are actually being used for those stated objectives? And even then, it could be said that it's a health project, but just because it's indicated as a project for health doesn't mean that it's going to meet human rights obligations for the right to health. We know that there's different considerations when you're using a human rights-based approach, right? And so those are some of the questions already. If there's greenwashing, if you extended that by implication to also social objectives, the question would be, to what extent are we actually meeting human rights obligations through some of these projects? And those are some key concerns, especially if a government is borrowing, particularly for that, then we have to be able to translate that into human rights obligation. Otherwise, it can be problematic. Another example, the flip side would be when a government fails to repay the money that it borrows, for instance, for a social bond, right? Who is facing that? What are the implications of that? Who would be facing those implications? Would it be the citizens? And then what does that look like if a government borrowed debt which we thought was going to be used ideally and would translate into human rights commitments being met, and then when it fails to repay those debts, and some of the consequences that we are already seeing with debt defaults, where governments then have to undertake measures such as fiscal adjustment to be able to repay debt. So we're seeing who is shouldering the burden of increased tax revenues at a local level, who is shouldering the burden of of expenditure cuts. So those are some of the things coming to mind when we think about those types of bonds, the thematic or GSS bonds, but also the cost of borrowing, because this is not concessional lending, it's non-concessional lending, and it's going to also be at market rates. There's the question of whether there's a greenium, an advantage, a small advantage that investors will give, so you charge less interest because of the benefit that comes with those types of bonds. But studies have shown that that's also questionable, and in some places, sometimes it's really minimal to justify that from the ordinary bond. So it's almost, are we labeling a new class of bonds that's just going to increase the borrowing in a where we have a system where countries are not able to easily restructure debt, or that's actually going to just keep them within a debt trap. So that's definitely something to keep in mind. And then the second question on bonds was around how the human rights question will be dealt with, and I think I've partly answered that. So for me, it was the concern I was raising was, if we say we are borrowing these types of sustainability bonds, which are you using to realize your SDGs, then we then actually have to be thinking about, and the different entities that are involved in this, including the rating agencies and the assessors, would need to then think about what are the human rights implications from the point of contracting this debt. So if we are saying we're borrowing a social bond, what are the adverse effects that would come from this, right? Who is going to be accountable if you issued a bond and investors have purchased, and then the project goes south, or there are negative adverse impacts from such projects? Who is going to be responsible? Like the previous speaker just spoke about, the IFIs now have structures, accountability mechanisms, but those don't exist where you're dealing with private creditors, right? So those are just some of the issues that we need to be also thinking about when we are hearing about the uptake of these types of bonds, and whether they really are benefits that could be derived from a human rights perspective, as opposed to borrowing no more traditional vanilla bonds. The other question on creditor composition, the issue of what my concern with, I think the question was whether it's diversity of creditors or the issue of repayment. I think it's both. And when you talk about diversity of creditors, it becomes even more complicated in this where we don't have a system for restructuring for multiple reasons. So I'll give you an example. When you are looking at the current G20 common framework that was created to allow countries to restructure debt, like I mentioned before, only bilateral creditors, official bilateral creditors, are the main creditors that are envisaged, whereas private creditors are encouraged to participate, and multilateral creditors are not necessarily participating. So the problem with that is that different countries have different types of different creditor compositions, right? So using the example of the countries that are currently restructuring their debt, there's Ghana under this framework. There's Ghana, there is Zambia, Chad, Ethiopia. And for Ghana's, the biggest proportion of Ghana's debt is held by private creditors. The biggest proportion of Zambia's debt was also private creditors. When you look at another country like Malawi, which opted to do the restructuring outside of the framework, the biggest proportion of its creditors are multilateral creditors, right? But that does not, so already for those countries I've named that are currently restructuring, their biggest creditors are not necessarily participating in the process of restructuring. And so they are then left with the option of having to negotiate privately with their private creditors, who, of course, although they might not hold the biggest proportion of debt, even in countries like Malawi, in some years have been receiving a much higher proportion in terms of debt repayments. Why? Because it's non-concessional debt, and it is charged at a higher interest rate than the one that you're getting from at concessional rates. And so the more creditors that we get with such complications already at hand, where some creditors are not participating and the ones who are being encouraged, there's no sort of stick to ensure that they participate and get to the negotiation table. What happens is countries are struggling to get all the creditors on board and are having to do these negotiations. It's obvious that there's a power imbalance between the countries and the creditors that they're negotiating with. And so the more creditors we have on board, and now we're seeing with this uptake of, for instance, thematic bonds, you even have another class of investors who are now interested in, ensuring that their finances are invested in projects which could meet human rights obligations insofar as they are social objectives. But the challenge is, are those investors going to be open to offering debt relief when a country can't pay their debt? Are those investors willing to come to the table? Will they have a different ethos from the current investors that we have been seeing? But even when you look at the bilateral creditors, the official bilateral creditors, we then also have the non-Paris Club creditors, who are also lending, and so it's just the multiplicity of creditors makes the process delayed. Number one, it's much longer process. For instance, countries which indicated that they were in debt default by like 2020, 2021 are still in the process of restructuring, are still in the process of just trying to get creditors to the table to negotiate. Maybe they will agree. In the case of Zambia, they will agree with bilateral creditors, and then they are required to now get an arrangement with private creditors. In the meantime, they are continuing to repay debt, and at the end of the day, the burden, the big chunk of the burden is going to the citizens whose human rights obligations, who are facing human rights violations. And mostly you see, it's not just the social and economic rights, like it would be, ideally we think, it's just, but then there's also the political and civil rights where people are not able to speak up and speak out freely about some of these things, or to question the borrowing of their countries, discussions around participation. So I think it adds the multiplicity of creditors definitely just complicates the problem even more and has even more implications when we think about it from a human rights perspective. Then there was one more question around the debt swaps.
Can I be heard? Yeah, sorry. We are running already over time, and I need to give our other speakers and panelists enough. So if you could very shortly, please wrap up. I didn't want to cut you short, but we do need...
Just 1 minute. Please. Thank you. So around the debt swaps, yes, so this is not just something that we're thinking about also in the context of health, like in the pandemic, but also for climate. There's been proposals around debt for nature swaps, those types of arrangements that are actually underway. What do I think about these types of financing mechanisms? I think, number one, they are piecemeal. The proportion of debt that is dealt with in a debt swap is much less. It's a very small proportion, especially if you're dealing with a country that already has a debt problem, that already has unsustainable debt. And even the IMF has recognized that in cases like that, the best option would be debt restructuring. So the problem with some of the promotion of some of these options is that the swap is really a small proportion of debt compared to the bigger issue. And it takes away from the bigger discussion around reform of the debt, the global debt architecture. So another key issue, of course, is the transaction cost that has been raised. It's quite expensive, and there's many players that are involved to actually facilitate this process. So I'll just leave that for now. There should be a study coming out by Afronomics Law around debt for nature swaps. If that's a topic you're interested in, it should be coming out in the next 2 months. I'll be happy to share information on that. Thank you.
Thank you very much. I think we started a little bit late. In Vienna, we have the academic quarter, but we should not excessively do this for the next panel that we are having, and there should be a break. So I asked the panelists here to briefly respond to the questions of the audience.
Yeah, I'll try and be very brief. So I'm glad you disagree. I mean, we don't need to convince each other as long as we can have a dialogue, you know. But so how is it a cycle? So now, the reason I look at it in terms of a cycle is because the role of a central bank during the 1940s and 50s, especially after the Bretton Woods system, right, at that point in time, price stability or inflation control was not the priority at all, right? It was about how central banks can and must use their instruments for economic growth, for development, and so on and so forth, right? We have come back to that conversation today after the financial crisis, for instance, the ECB, and this is something we were talking about yesterday as well. Now, there is so much literature out there, but also the ECB's strategic review that happened, I think 2 years ago, where now they are trying to see how best to interpret the secondary mandate so that it is in line with things like climate change and inequality and so on and so forth, right? So the reason I call it a cycle is because much of what central banks are trying to do today, including the Federal Reserve, the ECB, with respect to their mandates and trying to see beyond price stability, right, is not a new development, is not a new thing. This has been in practice for a long time. The only intervening time was from the 1970s until the 1990s, and more or less in that period when there was this global wave of central bank reform where everybody was changing their central banking mandates and putting price stability as the primary and as the primary mandate. And it was, of course, led also by international financial institutions, especially the IMF, which came down with its conditionality and surveillance instruments to transpose price stability and central bank independence into its membership. And this is something that Rosa Lastra narrates very clearly as to how price stability and central bank independence became almost a graduation issue for central banks, that it became a credibility issue for central banks, that unless they have this mandate and this mandate alone, they're not doing the right job, right? So in that sense, I feel it's a cycle because conversations that were happening in 1945 about what a central bank should do with respect to inequality, development, poverty, and so on and so forth have become important today. But this is not a new conversation. This has a long lineage in history, if it makes sense. But we continue the conversation. Right, quantitative easing. No, absolutely. So quantitative easing has been explicitly shown to have very large distributional impacts. And it is quite clear from the structure of how quantitative easing works that people with financial assets are going to benefit from it in the end, because quantitative easing at the end of the day is buying up more financial assets from the market, right? So asset prices goes up. And also quantitative easing has been shown to be extremely disproportionate when it comes to the kind of assets that are bought by central banks. More often than not, those are assets that are of companies with high carbon impact or oil companies and so on and so forth, right? So what should central banks do? I don't quite have a blueprint, but I do imagine that we have examples from different parts of the world and there is no straightforward answer. So for instance, if you're in Bangladesh, I think the Central Bank of Bangladesh is doing a wonderful work in terms of using its monetary policy instruments with respect to the microfinance industry there, which is a very important element in its social solidarity within Bangladesh. So the role of the central bank, I think we must open it up and think of it as a very multifaceted thing rather than a technocratic institution pursuing a singular goal. No, but it has many different instruments, many different objectives, and we must be able to explore those. Thank you.
Mm-hmm. Thank you very much. And I finally give the floor to Werner Raza.
Well, thank you. Thanks also for the very interesting questions and comments. Well, with respect to Katja's questions, is there some kind of competition or cooperation between Western lenders and China? Well, I mean, I think it's well known that China has become a very important bilateral lender. Internationally, it's become the most important lender for many African countries, for example. It's become very important for many South American, Latin American countries. And it's not very clear what kind of human rights conditionalities China applies in that kind of lending. I think this is still a very opaque area. It is somehow different, I would say, and that relates to the question by Mr. Stuck. What about the BRICS Bank and the AIIB, and what kind of conditionalities do they apply? These banks, more or less, officially, at least formally, they follow the IFC performance standards and World Bank safeguards. It is, however, difficult to really have a look at how they apply them on the ground, how they really, what kind of effort they put into the assessment procedures. But since, for example, the AIIB does have Western members, the AIIB is more or less funded by China, but there are, Austria, many other European countries are members, official members. So the AIIB does have a cooperation agreement with the World Bank in applying World Bank standards. So my impression from the AIIB and from the BRICS Bank is they do have to have a certain formal commitment to those standards. It's difficult to really have a look at their internal procedures, how they apply them. I would when you look at the literature, to the extent that there's knowledge about that, it seems that these banks do not significantly deviate from the assessment procedures of the World Bank, and they are rather risk averse in their lending so far. So they are not the risk takers to a similar scale as the Chinese banks, for example, because they have a limited capital base. They have a lot of different members. They are not very risk prone, to be honest. What you see with respect to Chinese lending is certainly that China has linked that to its geopolitical ambitions. It's been rather aggressive, I would say, and in giving money to countries. But I would say that cycle of very generous funding more or less comes to an end now. What we see is that China also does have problems in terms of restructuring its debt. Its lending practices have become much more circumscribed in the recent past, and the volume goes down. For example, in Latin America, South America, that's very visible. So I think China is also running against certain limits, if you want. And finally, how do you kind of weigh the right to development versus human rights, or how do you kind of see the right to development as an important economic human right, if you want? Well, I think that's a very difficult question. My impression is that these human rights impact assessments, or these human rights assessment procedures that development banks have implemented, in many ways, safeguard and support the also economic rights of affected populations. What we see in many cases is that the right to development, which is used for justifying certain large infrastructure projects in Africa, they lead to a situation where the rights of affected populations are not really taken into account. So in a way, those countries are repeating the mistakes that, say, Europeans or Americans have committed during their process of economic development. So I think, and also, coming back to this Ilisu Dam project where I've been involved, often in those projects you have a severe political conflict between the central government and the affected population, because the affected population has a history of struggle against the central government. Like in that case, it was the Kurdish population in that area against the Turkish central government. So the process that is supported by the Development Bank actually helps to kind of safeguard the rights of the affected population, which for historical reasons does not have any trust in the central government, where the central government does not, give, also has a lot of problems with the local population. So there's kind of this intermediation also that is facilitated by that process. So I would say one has to have a very qualified look at what the right to development really entails. And I'm a bit skeptical about some of the discussions that you see coming from governments of the Global South that say towards Europe and the United States, you shouldn't teach us on what the right to development is. Well, yes, of course, but the point is, and that's the source of legitimacy, I would say, if you take our money, there comes some kind of human rights obligations with that. If you find other sources of finance, that's your legitimate right. But if you want money from the global community in the form of World Bank or IFC credits or from European money, European sources, I think there's a legitimate case to say, okay, that money comes with certain strings attached.
Thank you very much. Thank you for this exciting panel. And as you've seen, we run a little bit over time. We were not intending to fully restructure the program envisaged by those who planned this conference. We had some structural adjustments to the program, I would say. Let me conclude and ask everyone to give a round of applause to our panelists, and thank you for the lively participation in this debate.
Thank you.